she could work more, but just chooses not to. And I can't figure out how child support would be less now than when I paid it when he was 12, 13 years old.
And did you get a chance to review Mr. Zandy's pleadings?
Yes.
And do you have any issue with what he submitted?
Yeah.
Okay, let's start there. Go ahead.
Well, I also have a daughter, a second child, Kennedy, age 11. The last time we did support, we did not use the whole family dividend, so I asked it not to be used again this time, as we both have children. And since Shanna's last provided pay stub, she has received a retro paycheck for back pay for them ratifying their contract, which would give her a $6.62 raise. And the paperwork that she provided does not show her second job is the Tudor Lake varsity volleyball coach. I'd also like the court to consider that she could work more, but just chooses not to. And when it came to the medical insurance, she said she does, but that is paid in full through the Longshore Union. I also have kept providing Logan medical insurance that I have to pay through for my work. She did pay for half of his travel ball, but that was when he was still living with her, and has not bought any equipment for that. I have also paid for Logan's car insurance since before he turned 16 in full, and have been paying for his cell phone in full since he was 14. I have also paid for Logan's college baseball recruiting camps, and for his high school football camp too. And as for the post-secondary education, Logan has been in contact with 2 different colleges. One is Concord University in Stewart, Nebraska, and the other is Ottawa University in Arizona. He's planning on going to college, but he's just researching what college has the best criminal justice program before he commits. I asked that child support continues through post-secondary education. And for some reason, if Logan does not go to college, I asked the child support be paid till he is 18 or graduates, whatever comes last.
Mr. Zandy?
Yeah, I'll start backwards and work to what I think is the initial comments made by Mr. Barker. We would certainly agree that child support goes until Logan graduates high school, which will be this June. This is a 17-year-old child who I think everybody admits is a skilled baseball player. We anticipate and hope, and that, pending anything unforeseen this spring, that he does get some opportunities to play at the college level, as that's been the child's goal for some time. And I understand he's a good player, so that's there. So my client does anticipate paying child support through June of 2024 when Logan graduates. In the meantime, he's going to be 18 in February. So as far as a parenting plan is concerned, I don't think we really need to spend the time and resources to delve too deep into that, because this is a child who has lived with dad since spring, has made the intentions known. The parties, to their credit, have kind of accommodated that, recognizing that he's on the verge of being an adult and making his own decision. So we're good as it pertains to the parenting plan, and just kind of keeping the status quo and letting Logan, who is a typical 17-year-old, has friends, extracurricular activities, those types of things, kind of having some input on when he visits my client and essentially where he comes and goes. So we're good with that. As it pertains now to some of these other issues that were brought up initially by Mr. Barker in his response, I've looked through the pleadings, and again, I've been involved in this case and was just retained about 3 days ago. So this is a lot of catch up for me, but I didn't see anything related to pertaining to my client's back pay or the payments for football camps or anything like that. So I just asked the court not to consider anything that's outside the scope of the pleadings, as that is certainly new information to me, and I don't have my client's input on that. Can comment that I think the statute is pretty clear as it pertains to a whole family deviation. My client is the obligor, readily accepts that, is willing to pay support, but does ask that she does receive some kind of deviation for 9-year-old Tucker, who her and her husband are solely responsible for. Again, I think that's borne out by the case law and the statute, and we do ask for that whole family deviation. I would point out the voluntary retirement contributions. Again, it appears, and we plugged these back in, that Mr. Barker is contributing significantly to his voluntary contributions to his 401k to the tune of about $1,600 per month. Notice the difference on the worksheets. And again, we essentially use the incomes that were provided by Mr. Barker in his initial pleadings that were filed at the onset of this back in late September. So again, to come forward and say, well, there's back pay and there's all these different things, he's essentially contradicting the very worksheets that he provided barely a month ago. We did plug back in his contributions. I did give both of them credit for $417 again, which is allowed by the statute. That changes the percentages on line 6 of the worksheets. Also changes a little bit, not significantly, the amount of the transfer payment. If you build in that deviation, that results in a transfer of about $450 per month. We rounded up from the $449.66, and my client thinks that's appropriate, and the numbers in the worksheets seem to validate that approach. As it pertains to the volleyball income, again, that is information that I didn't see included, and if it's there, I apologize, but I didn't see it in any of the prior pleadings submitted by Mr. Barker. We did provide you with not only a pay stub and a W-2, but also the joint tax return from 2022 of my client and her husband. And that volleyball income, as you can see, is de minimis. There's just not a lot there, and it's really not going to move the needle in either direction very much. As my client does that, that's a couple of months out of the year, and it doesn't get a lot of money for that. So in any event, that is built in through the tax returns and evidence therein. If we look at post-secondary, and this is the one that in preparation of today's hearing, I struggled with a little bit. We're now in November, baseball season commences in March. And although we understand this is the first I'm hearing of the opportunities to play in Arizona, and I believe the other school was Nebraska, no idea what the cost is, no idea if there's any scholarship offers on the table, no idea if there's financial aid or where we end up with that. And at this point, we're essentially shooting in the dark. My suggestion for dealing with the issue is twofold. Number one, we just reserve on that pending further information. Now, when we know when Logan has decided where he's going to go, a lot can change over the spring. If he has a very good season, I anticipate he's going to get significant offers. If he doesn't, or the status quo remains, then we'll kind of see where that goes. But at this point, it's a wild card and a question mark, and we just simply don't know. So first and foremost, we can reserve on that and address that later in the spring when we have more information. Or secondary to that, my client is willing to just kind of adopt the standard approach to these things, which is laid out in her declaration. Number one, that Logan attend on a full-time basis and be in good academic standing. Again, that's detailed and specified by the institution he chooses to attend. That we also think it's appropriate to use the traditional approach to this, that the child is responsible for the first 1/3, parents based on percentage of incomes for the remaining 2/3. That would break down to about a 63-37 split. We think that's appropriate, and anything that exceeds Logan's 1/3 contribution through scholarships or financial aid rolls into mom and dad's 2/3 share on the percentages identified previously. We want him to be in good academic standing. We want him to be providing both parents copies of grades and such. And again, all the things that are identified in my client's declaration we think is appropriate. So as far as the post-secondary, I think either one of those approaches will get us to where we need to go eventually when Logan decides where he's going to go and we have more information available. Also asking finally on that post-secondary that we cap that at the Central Washington standard. It's somewhat mind-blowing how much private schools are out of state this day and age. It's always been that way, but it continues to go up. We just don't want to get in a situation where he chooses a school that doesn't give a lot of financial aid or support, and both parties are paying significantly for costs at a private 4-year somewhere out of state. So we are asking that Central Washington cap be applied in this instance, and again, I think that is reasonable and appropriate. Otherwise, I think this is a pretty basic. And I think the whole family deviation certainly applies. I think our numbers are accurate, and we're asking the court to adopt the relief as we requested.
Mr. Barker, anything you wish to add?
The retirement contribution, I went off of what I thought was what I applied to 401k, everything else. And the only stuff for her I had was back from 2012.
All right.
The last time we did the child support stuff is what I went off of. And I can't figure out how child support would be less now than when I paid it when he was 12, 13 years old.
Anything further?
And that's everything.
All right. So support will go through graduation from high school. We should use the whole family formula for both parties. I think it'll probably pretty much cancel out. If we need to use current income, so if Ms. Ford has a raise that isn't part of that, we will need to include that. So we're not back here right away. She does get the deduction for health insurance. That's per the statute. We need to cap the retirement contributions for both of them. Again, that's per the statute. In terms of extracurricular activities, it seems that we should use the percentage for any baseball related programs, because it sounds like that's going to be a contributor to post-secondary education. I don't think it'll make any difference in any event, but I think one job's enough. I'm not going to include any income from 2 months worth of volleyball coaching. And I agree with everybody that it doesn't seem to make sense to spend the time or money to establish a parenting plan at this point. Post-secondary education, I'm going to reserve with some direction. I would anticipate that it will be how we ordinarily do it: 1/3 to be paid by the child, 2/3 by the parents in proportion to their incomes. Presumably, that's as far as we'll go. My only concern would be if all of a sudden he gets a good scholarship to USC or something like that, where the parents' contribution is out of this world, we might have to revisit it. But assuming that it's something more in line with what Mr. Barker's talking about, I think that's where we should end up. But just to make sure, since everything is kind of in flux at the moment, we'll just indicate reserve. But I think with that direction, hopefully, once we know where he's going, the parties can sort out the contributions. That cover everything?
I believe so. And then just adopt the parenting plan that dad's custodian and kid can kind of come and go as he pleases with input.
As agreed.
Do you want me to draft the order on that, or do you want Mr. Barker to do that? He's the moving party, but it might be quicker.
I'm going to suggest you do it, Mr. Zandy.
I'm happy to do it.
All right. Presentation next week or 2 weeks?
Yeah, the 16th works.
All right. 16th at 9 o'clock.
Okay.
And I'll get to you via email, Mr. Barker. Does that work?
Yeah, that works.
All right. Thank you.
All right.
Thank you.